Good morning, everyone. So I'm the master of suspension and debarment, I hear. I was prepared to say that this was the only way, but Maria and Rod they've told us that this is not the only way. So there are a lot of different approaches, but again, I think as Rod just mentioned, we're trying to do things consistently and systematically. So I'll just move on into this, and again, as Rod said, I'm very new to USAID, and so I kind of have my foot in kind of both worlds, but I'm excited to have the experience of working at Department of Homeland Security and moving on into a new agency. So we're going to talk about suspension debarment. Just so I'm clear, if I can get a show of hands of people who actually do not regularly work in suspension and debarment. Okay, so about 40 to 50% of us. Okay. So we've heard these phrases, suspension and debarment. One of the most important things I think really to consider at all points of time is that suspension and debarment is not punishment. Rather, it's a means by which the government has to protect the public interest. Everybody knows the government actually, engages in contracting with, vendors all over the country, all over the world. But we only want to do that with individuals and companies that are presently responsible. So that's the purpose of suspension debarment, to ensure that those activities are done with contractors, participants that are presently responsible. And that's the catchphrase. You'll hear that a lot in suspension debarment circles, and that's really what the focus should be on. So those of you that are case junkies, you'll want to go look up this case, Perkins versus Luke and Steele Company. This is a case by which the Secretary of the Department of Labor was sued. I'm not going to get into the case. It's a very interesting case, but really at the core of it came one of these several notions, one of which is that contracting with the government, it's a privilege and not a right. So that's kind of an underpinning to a lot of what we're going to talk about today. So it's just important to remember that the government has the ability and the power to determine who it contracts with and who it conducts business with. And that's really what that case, one of the things that the case stood for. So looking at suspension debarment, there's various authorities, one of which is that there's an inherent authority and express authority. Express authority, as you might guess, it does come from statute, where you're actually told that you will do something. An inherent authority is something that really all government agencies do possess. The types of suspension debarment, there's going to be administrative, and that for some agencies, that's really all they do. I know that for the most part, DHS, the types of suspension debarment actions that they institute are administrative, they are discretionary debarments. And then there are those statutory ones where you are mandated to institute a particular course of action towards a company if they engage in certain behavior. So the basic authorities, you all may not be able to see this, but there's two basic authorities which suspension debarment is actually instituted under, and that is the Federal Acquisition Regulation, the FAR, and then the Non-Procurement Common Rule. So all of what we'll be talking about today, that's the authority. So, and you'll see we talk about 48 CFR, Part 9. So again, if you open up the FAR, that's Part 9, and more specifically 9.4. And then we're talking about 2 CFR, Part 180. So the last sentence there's some differences, but both provide similar protection. That is true. You could institute suspension debarment under both authorities. I will say from experience, the NCR, the Non-Procurement Common Rule, is a little bit more user-friendly. It's less technical, and but both have, there's some differences to both, and a nice read of that one Sunday morning would definitely give you, see what those are. So definition of a contractor, there's two different entities that we're going to look at here, contractor and a participant. The contractor is really who the respondent is referred to under the FAR. And the NCR, the Non-Procurement Common Rule, you'll be dealing with participants. So here, I'm not going to read the definition. You all can see it. But a contractor is really somebody that, of course, submits offers for is awarded contract. One of the neat things about the definition and the FAR, you can see number 2 there, reasonably may be expected to conduct business. So in a way, you would say that most companies are going to be a contractor, whether or not they have previously contracted with the government, whether or not they're current contract with the government, or they may be submitting a bid or proposal to actually contract with the government. So it's a very expansive definition, and it's a very helpful definition when you're actually doing the work. Then we move on to participant. Any person who submits a proposal for or who enters into a covered transaction, including an agent or representative of a participant. Very straightforward definitions. So looking at suspension and debarment, what is it? Now, I imagine that you all have probably heard of the website, the Excluded Parties List System, the EPLS. Show of hands, who's heard of that? Mostly everybody should. Show of hands if you know that that is no longer the system that is currently being used. Okay, hopefully the same amount. If you look in a lot of the regulations, you'll see EPLS still listed routinely. I think that might be a to-do list for those entities to update it, because we now use SAM. We'll talk more about that. There'll be presentations on SAM as well. But suspension and debarment is an exclusion, and those exclusions were listed under EPLS, Excluded Parties List System. It was a list that's really essentially one of the major pieces of SAM. It's a list. It's a list of individuals who should not be contracted with or given public assistance, federal assistance, excuse me. And importantly, there's only the agency SDO has the authority to suspend or debar. So not anybody can just declare you suspended or debarred. It actually has to come from the proper authority. So there's I'd say two main areas in suspension and debarment world. There are different administrative actions. We will talk about those, but the two main ones, of course, of suspension and debarment is suspension and debarment. Suspension is an action taken to address an immediate need. I think that's very important, that concept of immediate need. That's really important when you're actually instituting a suspension. Debarment, specified amount of time. You'll see in the FAR, we'll talk more about this, but it's typically for a general 3-year period of time. So getting into a suspension, and you can see the citations there for both the FAR and the NCR. Most of these slides will have those. And I'll read this. A suspension is a serious action imposed based on adequate evidence and when immediate need is necessary to protect the government's interest. So again, we're talking about protecting the government interest. And this is going to be for a temporary period of time, oftentimes pending the completion of any legal proceedings that have been instituted towards that contractor. It can be imposed upon a variety of reasons. Oftentimes the same cause is the same cause for if a debarment exists, and then also if it's in the government's interest. Most oftentimes you definitely want to look at it and make sure that it's in the government's interest to institute a debarment. A cause for debarment may be established upon a variety of reasons. A criminal conviction is a very common one. A civil judgment, preponderance of the evidence. Very important to note in suspension debarment is the burden initially starts with the government. The burden then shifts to the contractor to present issues contrary to the findings of the suspension debarment official. So looking at the causes, The causes of suspension and debarment, again, are listed there. Those are the citations. And I'm not sure, Maria, are these slides going to be available later on? Oh, posted. Yes, they'll be posted on the website. I'm guessing that I'll do that. Okay. So some of the causes are criminal and civil violations. As you can see, there are violations related to public contracts and transactions, so fraud, antitrust, theft, bribery, any type of action that you believe would shed light on the fact that the government would not want to conduct business with that contractor or lend assistance to that individual. Some statutes, the Made in America, drug-free workplace, these types of statutes, violations of those are going to be causes for either suspension and debarment. Continue on with some of the causes. Even failure to pay a single substantial debt, that is a cause. Now, of course, we're going to talk more about this, but you really want to, of course, these causes on their own aren't going to be enough for a suspension debarment. This is part of a larger picture, and you're going to, of course, need to find the nexus between these causes and the need to actually institute suspension and debarment proceedings. So I talked a little bit about this before, but a period of suspension is going to be a temporary period. What you all see there, it's initially no more than 12 months. That's prescribed in the guidance. And if legal proceedings are not initiated within 12 months after the suspension, it can be extended for a period of 6 months longer. And then, as you see, it may not exceed 18 months unless the legal proceedings have been initiated for that period of time. So if the legal proceedings are initiated, and if those take longer than 12 months or 18 months or a year or 2 years, then that's okay. You can still, the individuals can still stay within that suspension status. But remember, the most important thing is that there's an immediate need. So you would not have gone back and forth with the contractor. The government would have said there's an immediate need to suspend this contractor. They would have had the causes that we previously talked about, and they would lay the suspension because it was very timely to do so. So looking at the period of debarment, I think debarments are a little bit easier to conduct there. I don't want to say, in a way that they include the contractor. You do go back and forth with the contractor a lot initially, but I think that they're much more cleaner. And it feels a little bit easier to do a debarment because, you're not really, that you're not about to surprise a contractor. It has gone back and forth. You certainly can say that they've had due process. There is due process in a suspension, of course, but, as a practitioner in the field, when you're instituting a debarment proceeding, it definitely, in my experience, is that it feels different. But looking at a period of debarment, the period is going to be commensurate with the seriousness of the cause that we talked about. As I said, 3 years is the general timeline that a debarment would take place. Now, sometimes a debarment may take maybe no more than a year or 2 years. I know at ICE, I can say that we have some that are mandated that it's 1 year, and we've conducted them up to 99 years. So there's the gamut right there. I think 99 years might be considered life. For us, we consider it life, but we used a specific number because you actually have to use that number. You have to make it very specific and defined when you're putting it into SAM. But I think the point here is that the period can be, there's a range, and that's important. But there is a guideline that 3 years is really the basic starting point from there. And if you feel like there's some aggravating circumstances, you would then go up from there. If maybe there are some mitigating circumstances, you might go down. And we'll talk more about that as well. And I'm sorry, one thing I wanted to mention is that the period of suspension should be considered. So in practice, if you decided to institute debarment, a debarment to a contractor that was previously suspended. So if that debarment would have been 5 years and they were suspended for a total of, let's say, 1 year, then the initial period of debarment would be for 4 years. I think that's a common practice throughout the federal government. So just keep that period in mind.
Brad,
Yes.
what do you do if the party's incarcerated?
It's a good question. Parties incarcerated. Of course, depending on the agency, depending on the different types of referrals and intakes that they do receive, sometimes an individual may be incarcerated. So Norm has asked the question of what do we do when an individual is incarcerated, and an individual responded that you're instituting suspension debarment action on. I would say there's kind of two schools of thought. Some would obviously, some agencies will look at the individual's incarceration, and the period of debarment will only start at the expiration of their incarceration period. I think that is the prevailing norm. No pun intended, norm. But that's what I think typically occurs. So if an individual is incarcerated for the next 5 years and there was a period of debarment that was going to be 3 years, that individual would be debarred for the next 8 years, if that makes sense. So I think I'll stick with that because that's the prevailing thought, and I think that that's the option that does protect the government the most. Now, of course, we'll look at this, but an individual can always respond to the government and present mitigating factors to show why they shouldn't be, of course, debarred for the next 8 years, including 5 years of their prison sentence and 3 years of the debarment period. So they can always come back to government, but that's the traditional norm.
Right.
Yes?
Let me just add to that. Some agencies actually do start with debarment during the incarceration. We've had experience in DC where there are people who actually have gone to jail and started up businesses in jail and continue to operate. They have an oversight person that comes in. And so there is some merit also to debar the person while they're in jail.
If I wasn't clear, that's what I meant. That's what I meant. So the debarment would start now, but it would take the course of 8 years. But you would include those first 5 years, and then the 3 years of if that would have been the debarment period that you were looking for. But you would actually go into SAM and you would log that as an 8-year debarment period, and that's what you would communicate to the respondent. That is an 8-year debarment period. So you do include both. Sorry if I wasn't clear.
Okay. Say real quickly, if you have questions or dialogue, please use the microphones. There's one here and there's one in the middle of the room. This is being recorded, plus us in the back, we can't hear anything if you just talk without the microphone. So please use the microphones.
So moving on, looking at the evidence that's needed, there's the citations of where you can find this in the FAR and the NCR. Information that you need information that's sufficient to support the finding. There's some examples here of what is sufficient. An indictment, of course, search warrant, reports from an auditor, your IG community, and then of course you see what's probably not sufficient, just a typical news article. Civil settlement without the admission of guilt is also probably not adequate enough. And then you look towards the immediate need. So we're talking about a suspension. It's not defined. So that really is up to the suspension debarment, the division, the SDO, to look toward what is immediate need. The decision to suspend is prudent given the risk potential under the circumstances. So it's all about the risk potential, and of course that definitely is relevant when you're looking at the immediate need. So I'll continue. So the reach of suspension debarment, as you all might guess, when I talked about the definitions of a contractor and a participant, those are very broad definitions. Looking at suspension debarment, the reach is also very wide. Of course, you can debar an individual, but not only that, the FAR and the NCR give you the ability to impute conduct to an individual. Seriously improper conduct can be imputed from the individual to a contractor, from a contractor to the individual, in some cases from a contractor in a joint venture type scenario to other contractors that are working alongside them. In practice, I would say that oftentimes this does happen. It happens a lot, and just because you might not get a referral on an individual, it doesn't mean that they may not find their way looking at suspension debarment action against them, because really you want to, the whole goal here is again to protect the government. And so there's various remedies that the FAR and the NCR give to do that. So looking further, imputed conduct and actually debarring an individual, there needs to be some level of knowledge. So if an individual I think typically a very good scenario, just kind of paint the picture. If you have an individual who, let's say there's four individuals in a company, they are very senior authorities. You might have the CEO of a company, you might have the president, you might have some of the managers. Those individuals may be facing criminal action. So there might be debarment proceedings instituted against them. Now the question is, do you want to continue those debarment proceedings to the company? So the question is there knowledge? Do you want to hold that entity responsible for the acts of the offending entity such that both entities are deemed culpable or blameworthy of the offending act? A very fancy way of saying that if one did it, is that responsibility, that culpability transferred to another individual or the company? Last thing there is reason to know, not should have known. So you don't want to, in practice, say, well, the individual should have known. That's not enough. They had reason to know. And affiliates, another way that suspension debarment is very expansive. The most important thing about affiliates is control. Just to kind of paint a picture here again, if you have a company, they may have other companies, maybe as subsidiaries, and they may have nothing to do with the bad acts that occurred. But the question is, does that individual who is facing suspension debarment action, do they have control over those other companies, again, that may have nothing to do with the acts that occurred? And I will say, I just want to back up one moment. Affiliations can occur between husband and wife. If my previous Randy Sawyer, as many of you know, he used to love talking about a car wash. So if there's a company and they actually own a car wash, for example, now the company, the parent company, has nothing to do with a car wash, but that company may own all these other different companies, and one of them might be a car wash. It may have nothing to do with the bad acts that occurred, but you have to kind of put yourself in their position for a moment and think, do they have control over this company? If they do, we want to protect the government from that individual maybe operating in a different way. So you might debar that top-level individual or company, and then you might also debar those different bottom-level companies. And in practice, you'll find that an individual may come back, and they always will say, well, this company has nothing to do with my parent company, the one that actually was convicted, or I was the one convicted, not these other companies. They have nothing to do with it. Again, it's about protecting the government. And if there's a nexus between that individual and you find that there's control that they have over that affiliate, it may be wise to conduct suspension debarment towards those affiliates. Now, it's not automatic. You don't have to do it. And there are times where you will say, yes, they do. They may even actually exercise control. But that doesn't mean that you actually have to institute such action. So continuing current contracts, the short point here is that existing contracts or subcontracts can be continued. And for contractors that are debarred, there's certain things that cannot happen. You cannot place an order. You can't go out and conduct a new contract, obviously. You cannot add new work, exercise options to the contracts, etc. Now, de facto debarment, this is a very interesting concept. De facto debarment it occurs when the government withholds a contract or an assistance award from someone who actually is eligible. And they make a determination. They may say it's based on its lack of business integrity, but they do so without resorting to the actual debarment process, the process that we're talking about here today. So if you can just picture a contracting officer who may believe that there is improper conduct that a contractor or a participant has engaged in, but what they're really doing is they're essentially acting as the SDO. And this is something that is not allowed. And so repeatedly using their responsibility determination to preclude a contractor can incur very severe penalties. The reason why it's improper, we talked about that they don't have a right to contract, but they do have a liberty interest that's at stake here. And for those contracting officers in the crowd, if you're here, de facto debarment does have some consequences. So there may be injunctive relief that can be instituted by a court. And then, of course, a variety of damages and fees that you don't want to find coming your way. So the important point here really is that if there is behavior that a CO might believe warrants suspension debarment action or warrants precluding a contractor from receiving an award, it's important to actually facilitate that and to push that in the direction of the SDO, so to institute those official proceedings. So, administrative options. We've talked about suspensions and debarments. There are some other administrative options that are available, and I'm sure you all have heard about a variety of these. And in many ways, I would say there's different levels of consequences for these. I think that it's really important before you engage in any administrative action to really think, what is my end goal here? Where are we going with this? The first one there that you'll see is request for information or show cause. Oftentimes the government you have the ability to actually say, we want more information. We need to know more. You may have something that might be incomplete. Something that actually, if that record is augmented, it may lead to a determination that you would want to proceed with suspension debarment action, or it may actually say that there is nothing here and we should not proceed. Of course, we talked about suspension. Suspension is an administrative remedy. Then, of course, we talk about debarment. Obviously, before you debar somebody, you do propose them for debarment. That is a mandated stage that you'll engage in. There's also an option to institute a no action or transfer that to a sister agency. Obviously, for a no action, there's a variety of reasons why you might institute that, but that's really up to your agency to decide. And you may decide to transfer that action to another agency. You might transfer that action. You might receive a referral from your IG, and you might realize that another agency might have more contracts. If your agency might have $5 million of contracts, but then another agency has, $400 million, it might be more prudent, or depending on when the contracts are, it might be more timely to transfer that to another agency. They may have more expertise in the area that the conviction, might fall under. So, really looking at that transfer, I think that that's transferring to other agencies. I think it's going to build the government's suspension debarment program itself. Then, of course, you can find them responsible, and that's always, I'll say from experience, it's always a nice thing when you're able to find a company responsible. The types of referrals that we get doesn't always lend to that, but it's still nonetheless very refreshing when you can say this company is responsible. And that's what we're really looking to deal with here. Then, of course, there's the debarment. And then there's a voluntary exclusion. Voluntary exclusion, if you all don't know, it's just like it says, a contractor may contact the government and voluntarily exclude themselves. You'd say, why would they do that? I think they may be able to see themselves as a non-responsible contractor for a particular period of time. Maybe they know that they need to get their shop in order, their company in order, their proceedings in order. And the nice thing about voluntary exclusion is I think it's always a mitigating factor when a company comes forth and says, we feel like we should be debarred because of particular issues in their company, for example. And that may actually, I think it's a nice thing. It certainly lends to that contractor being on the road to being a responsible contractor. And then probably the most complex of all of them is an administrative compliance agreement. These take a lot of work, but looking at the above administrative options, suspension debarment may not fit a particular contractor. It may not be in the government's best interest to institute a debarment towards a contractor. So you have to really look at it, and if the conditions are right, then maybe there's a compliance agreement option on the table that it can be a win-win for both. Really, the government, the goal is not to debar, it's to conduct business with entities that are presently responsible. And if you can find that right contractor that you believe is on that road, is right there on the cusp of present responsibility and maybe not being so, and entering into an agreement may actually assist them to getting there. They may be the right candidate for that. I know we're going to talk more about compliance agreements later on. I don't want to steal their thunder. So some initial steps. So just again, trying to get some audience participation here. How many of you all actually have engaged in doing something like this? So conducting suspension debarment, like on the ground in practice. Just so I'm clear. Okay. So again, about half of us. Those of you that have done this, you'll know that you obviously have to conduct, it may be wise to conduct research and conduct analysis at that moment. It really depends on what product is given to you. If it's a complete package, and we'll talk more about that, but if it's a complete package and what that institutes, you may not have to conduct any research whatsoever. In practice, I find it's helpful because it's really your name on the line at that point. It's important to find a nexus and really decide, what is the administrative action that you're going to proceed with. Again, if there's very little research and there's very little information available to you, maybe a show cause. If there's a conviction and it's very clear, very straightforward, that nexus is there, you may proceed at that moment to propose for debarment stage. And then prepare the administrative file. This is fun. It's nice to always do paperwork, but you're going to have to consider, is this, there's paper and electronic records. There's a difference between like an admin file and an SD file. And I know that this is going to be talked about throughout the day. But it's important to obviously start building the record because everything that we do always comes back to the record. And then, are we going to include some affiliates? Are we going to impute, as I talked about earlier? Which rule are we going to use? Are you going to use the NCR or are you going to use the FAR? You really want to decide up front what rule has the greatest nexus and proceed down that path. There are some differences, but for the most part, I would say that depending on is it an individual that you are instituting action against. If it's an individual, you're probably going to be on the side of the NCR. If it's a company, a contractor, you're probably going to be on the side of using the FAR. There's some room to move there, but that's the general path. Then, second to last there, prepare and send the lead agency email. This is something that the ISDC is really trying to push as very important. One, it ensures that the other federal agencies are all on the same page, and that those other agencies that may be affected by a suspension or debarment towards a contractor that they are working with, that they know what's happening out there, and that It's not a total silo concept throughout the government. Of course it is with different agencies doing the action, but if you think of like a Venn diagram, this lead agency email is really that connected part there, where everybody knows what is happening throughout the suspension debarment community. And then tracking these cases in your case management system. Case management systems have been a hot topic, I would say, in the last few years. I know that some agencies use no more than Excel spreadsheet to track their cases, depending on the complexity of your program and the really how large it is. That will really determine whether or not you are going down the path of a full-blown database that may cost a lot of money to procure, or a simple Microsoft Excel license. So that's really depends on the program, the size of your program. There's some research websites up here. You may not be able to see these, and they're not for you just to take down, but obviously it's going to be important to conduct good research. There are a few sites here that I want to just highlight. I mentioned SAM before. Those of you that are not familiar with SAM, I'd say it's getting better, and it's some laughs in that. It is definitely getting better. It definitely looks better than EPLS did, but it is, as you can see, it's a system for reward management. The intention is to have a lot of different award issues kind of centralized into one site. But the most important and probably the most frequent use of SAM, that's where you go to check to see, maybe if a contractor is previously suspended or debarred. So of course that's going to, lend to maybe the period of debarment. If a contractor is currently debarred for 3 years and they engage in bad behavior, that comes to your office, and then you're considering suspension debarment action. It'd be very helpful to know if they already are suspended or debarred. So you want to look there, and of course that's where your contracting officers are going to look before they actually offer any contracts to any one of these contractors or companies out in the field. Also, USA spending. Now, this I really want to see a show of hands. Who actually has been on usaspending.gov? And who has never heard of it at all? Be honest. A few? Okay. So USA Spending. USA Spending is in my humble opinion, an amazing website. I think it's probably one of the best ones that I've seen with a .gov address on the end of it. It is a good place to go if you're interested, one, just where's the money going that the government contracts with. You can look to see, of course, by state, by company, where are the public funds going. So, of course, this is very helpful to go back and look to see, well, maybe does this company actually have a contract? So when we're trying to draw a nexus with a company and maybe suspension debarment proceedings, that nexus might be bolstered by the fact that they do have current or past contracts. That's going to show up in this system, and that's very helpful when you're actually doing this work in practice. Looking at state websites, the Secretary of State of each state, it's important to go to these websites because you're oftentimes going to find out who is the who's the CEO, who's the registered agent of a particular company. Those are very helpful sometimes when you actually are, one, trying to find, who should you be actually corresponding with for a particular company. You can also just, you can find who those high-level officials are in a company. These state websites really allow you to tie all this together. And then lastly there, PACER, Public Access to Court Electronic Records. Very helpful website. If you don't have the access to this, I would encourage your shop to get the subscription because it's sometimes very helpful when you're trying to build a case. You may have a judgment, but you may not, and you may know that they might actually pled guilty to a particular crime, but it may be helpful to go and get that actual plea agreement. Or vice versa. You may have a plea agreement that may have been the only thing that you got, that you may need to know. Was there actually judgment and conviction? Very helpful website. Now this is just a general process, starting with the intake memo that comes from the field. That memo, that really comes to your agency's debarment coordinator. It might be hard for you all to see that with the light in here. But really what happens is you get that intake memo. So this process starts there, and it starts to go, it filters on into your suspension debarment shop. It may go to your division. You may have a coordinator that's receiving these. And this goes on through, you then write the action. You decide what is the action going to be here. Then, very important here, as you can see, that fourth box there is your agency's legal review. So you obviously, it's important to have, a second set of eyes checking what you're doing. And it'd be very helpful if you do have, a separate shop that's doing your legal sufficiency reviews to look at this. And then, of course, from there, it then moves on to the SDO's desk, and he or she will decide if they concur with the recommended action that's been proposed. So once these, I say referrals, and I'm going to correct myself. Every time I've said the word referral in the past, I've been wrong. So the word should be intake, and we're going to talk about that. But if you can just imagine, you get a referral from your IG community, you then start to decide, we're going to have, this individual is a perfect candidate for a debarment, so we're going to start with the proposed debarment stage. You obviously are going to then write a memo that really, it outlines all the issues that are found. It's a very expensive piece, and I understand that we do have copies of sample ARMs, as they're called, action referral memoranda, and notice letters. So you write those letters. The ARM is what oftentimes goes, it's really for the SDO to see. And he or she will look at that memo, and they're going to make their determination based off of that memo. I think a very helpful practice is that memo would then go to the respondent. So they see exactly what the SDO sees. Now that notice letter actually is being written, that goes to the respondent. So those things, those are written, they go to your legal review and then the SDO for signature. And in those letters, you're going to discuss any aggravating and mitigating circumstances. And then in the final thing that's really done is a recommended debarment period. So then the SDO will say yes or no. There oftentimes is some back and forth. I don't want you to think that this is just a straight linear process, and once it goes to your legal review, then it can't come back. Oftentimes it does come back. They may say, we actually think that maybe there should be a longer debarment period or less. This is a very fluid process, and it may seem mechanical, but I think when a suspension debarment group is functioning well, it's a very fluid process, and ideas are shared back and forth, maybe between legal and the division itself, and they go back and forth. So, SAM entry, the overall SD process does include entering these actions into SAM. If you do have a proposed for debarment, that SAM entry is going to go immediately in there if it's under the FAR, as you can see. That's one of the slight differences between the FAR and the NCR. So for those practitioners, when you're writing actions, if it's under the NCR, it's a little bit easier because you don't have to go in and put that proposed debarment into SAM immediately. Those actions only will occur once the final decision is made and a debarment actually is laid down. And then you're going to send your actions probably by U.S. Postal Service certified mail with a receipt requested. So the way you'd write some of these ARMs, and again, there's some examples of ARMs, but a no response is probably going to end up in a debarment. If you start and you propose someone for debarment, and if they don't respond, you must believe that that your facts were originally correct. If they don't dispute that, then why would it not end up in a debarment? It would. And of course, maybe you could even say that a non-response certainly is maybe an extra nail in the coffin of being non-responsible. You'll write a decision letter. You'll reference the arm. This again is in a debarment stage. If they do respond, it's important to respond to all of their all the different points that they bring up. The contractor, the respondent. It's very important. There's some words there: assertions versus proof. It's very important to distinguish the two. You will oftentimes get contractors responding, and they will throw a bunch of stuff out there. And if actually proved, it's certainly mitigating. But a lot of times you'll see just people asserting things that may or may not be true. So of course that starts the dialogue of the back and forth dialogue. So once someone asserts something, then please, you really want to work with them to make sure that they actually are giving you adequate evidence to support their assertions. So, as you might guess, a respondent who receives this notice of proposed debarment or suspension, many of them are going to want to respond, and they may want to have a hearing. It's important to have a hearing process established in your particular division. Presentation of matters in opposition. There's formal, informal hearings, and I think a lot of times I would say that in practice, a lot of times the respondent through their attorneys will come in and they will try to make this a very adversarial process. I think in practice, in best practice, it's really not seen as an adversarial process. The goal here is really about conducting business with presently responsible contractors. If they're not, then that's okay, and we won't conduct business with them. But really the goal here is you're working together and you're really trying to find out is this contractor someone who we want to trust with the government's money. In this instance, at this point in time, the burden is on the respondent to show their present responsibility. If you can think about all those letters, those actions, the arm that I mentioned earlier, that's the government side to show to demonstrate the burden of proof, where it's on them, and they put that out there. Now it's on the respondent, and that's a it's a tough spot to be in. But they have to come back to the government and to prove to us why they are presently responsible. Quite possibly, it may come up that an administrative compliance agreement might be a right condition for one of these. And of course, sometimes the attorneys in the field, they are going to think to propose these. Sometimes it's very clear that one of these the conditions are not there for the respondent, but really that's for the government to feel out in that room, in that time when they're looking at all of the different sides of this to decide are they a good candidate for it. But of course, on administrative compliance agreements, those differ in length and the complexity. You may have a compliance monitor and or an ombudsman that might assist with the whole process. Then, of course, you may find that individual responsible. And again, that's a nice feeling. So some remedial measures, some mitigating circumstances that exist. Now, if you all can just kind of picture, a company that does have a conviction against it, it's now time for them to make changes. Perhaps in their company, to prove to the government that they are presently responsible, or at least on that road to such. And oftentimes you'll find in practice that companies may not have effective internal controls or standards. And you may see they may start to put those into practice. They may have for example, they may have no ethics training. You may see that actually put into practice in their organization. Now, the wonderful thing is when that happens without the government telling them that they need to do so. But too often times, they stand back and they ask, what do you want us to do to show that we are presently responsible. That doesn't work very well, but that's oftentimes what happens. Again, did they bring this activity to the government attention? And if they did so, did they do so in a timely manner? Oftentimes this never happens, but you know, it's again a breath of fresh air when a contractor comes to the government and brings issues to the government's attention that could see suspension debarment action. And then, you know, did they assist in the investigation? Did they assist in, you know, did they cooperate? That's always something that you know, you can certainly think, well, is this going to be a mitigating factor? Some other mitigating circumstances were that they paid their criminal, their administrative fines. You know, did they receive prison or probation? If someone, you know, received 25 years or a lifetime sentence of, you know, in prison, that's probably going to be very helpful to you to know, you know, what type of, you know, suspension debarment, you know, term might be instituted. If somebody only got probation, that might be, it's probably unlikely that an individual should be facing, you know, a 30-year debarment period, and vice versa. So adequate time to reflect, you know, have they had adequate time to look at the issues, their conduct, be it a company or be it an individual, and do they recognize and understand the seriousness of their misconduct? Now that's a hard one, but the government agency, that specific government agency has to decide whether or not they feel like that actually has taken place. And then the aggravating circumstances, too oftentimes this is what you're focusing on, because obviously you've received this package and you are moving in the direction of suspending or debarring a contractor. But the question, is there actual or potential harm or impact? Actual harm, it's very clear. You know, did they engage in conduct that was clearly harmful to an individual, their company? An example would, of course, be if they stole money from their company. That's actual harm. You know, potential harm or impact. Oftentimes, this is individuals that, you know, are just on the verge of actually doing something. They may be planning to something, you know, something, or being part of a conspiracy that may not actually have landed, but you know, that's what the government has to look at. What type of harm existed? And all these circumstances, these come from, you know, the FAR and the NCR, so these aren't just made up, but this is what the regulations tell us to look at. So the question here is frequency of these incidents. If there was fraud, did they do this once, or did they do this, you know, over the course of 15 years? Every week they siphoned money, you know, from the checks of the individuals in the company, or they've been conducting, you know, fraud against the federal government for the last 20 years, just in small amounts, and this comes out. That would be an issue, and I think that would lend to saying there should be a longer debarment period for that individual or contractor than if maybe that was one time and it was a small amount, for example. Was there a pattern of wrongdoing? Again, were they excluded? You know, were they in SAM before this? Were they convicted for the same activity? To what extent were they involved? Really, that's something that you know, is also very important. You may have the mastermind of a particular criminal enterprise, and then you may have a low-level individual who may have gotten caught up doing the wrong thing, but they did it once, and maybe it was a very low level in itself. Did they accept responsibility? As I mentioned, the individual's position in the company, and was that action pervasive within the company itself? See, these are all aggravating circumstances that are important when you're actually writing these actions to recommend certain debarment or suspension periods. So there's always this question of the FAR versus the NCR. As I said before, the NCR, there's no initial entry into SAM when you do a proposed for debarment. The NCR, if the respondent replies, then they must provide more data, including any affiliates. The NCR does provide for more methods of of sending notices besides the U.S. Postal Service. That's always a nice thing. Again, you'll see that the NCR is a little bit more relaxed, I would say. The FAR is much more defined. It's not that that's wrong, but it's sometimes a little bit constraining. The NCR causes for suspension debarment are more expansive. And you can see that. So there's a few differences here. And the NCR does call out the possibility of voluntary exclusions. So now the fun part, actually doing this. So we talked a little bit about the theory behind this, but really doing it. So the questions here, where will suspension debarment actually be housed? Do you hold it within acquisitions? Honestly, that's probably the most common place that you'll see suspension debarment groups. But it's probably, although there's a definite fit, it may not need to be there. In many ways, you could also say that this is the talk of the town. People talk about this all the time. But maybe there's at least some appearances of a conflict of interest to the shop that's actually awarding contracts, being also that shop that's precluding an individual or contractors from receiving contracts. So how many full-time employees are you going to have? A common practice is, in many agencies, is to use interns. They provided, actually, I know our office, when I used to work at Homeland Security, a lot of valuable assistance, and in many ways kind of run the shop from their interest in suspension debarment, government contracting. It's a nice thing to see. One of the questions is, will the SDO be full-time or collateral duty? Most agencies, the SDO, that title, that role is a collateral duty. Few agencies have an individual that's their only responsibility. But it does matter, and depending on the size of the referrals that come in, depending on those, that will certainly dictate whether or not this individual can do this in a full-time capacity or not. So, will your Office of General Counsel provide legal support and the final review of products? And then who's going to send out those referrals to us? Now, of course, you don't have to sit back and wait for referrals, but sometimes it's very helpful with this siloed type concept where you do receive those referrals from your investigators, etc. So, the question is, should you use both rules? If so, should you adopt the NCR formally? Of course, you need to decide and make sure and know whether or not your agency has any statutory authorities that they're bound by. So then looking at, who is the SDO? And you need to obtain that SDO delegation in writing if that's delegated on through. Talked about a program with a siloed concept before. A siloed concept, really, if you think about it, there's those that are sending the referrals down. There's those that are actually receiving them and doing the work on the ground. Then you have a SDO, and then also you have your legal review. So the point here is, I think some of the best practices is where that solid concept exists. It doesn't mean that there can't be information sharing between the two, but I think it may be. I think some successful programs are shown to have that concept, maybe where you're not doing your own legal review. So you might be, it's probably very helpful to write and then also have another set of eyes looking at this for legal sufficiency. Some other considerations. You're going to have to obviously be registered in SAM, and it's in theory a real simple process, but in practice, getting registered in SAM might take a little bit of finagling. But once you're in there, once you're signed on, then you're going to need to use that to actually put in your actions. So when suspension occurs, you would obviously go to SAM, and there's timelines. We won't talk about that, but you will do those things. You need to have a SAM account. Obtain Westlaw and PACER accounts. Very helpful. Westlaw in practice is a great thing to have for last known addresses. It's very important to to know what the respondent's last address is. That's where we're supposed to send these actions to. And then PACER, as I said before, it's helpful to get some of the information on the case. Developing NARA guidance, archiving guidance for your agency. What do you do with it? Obviously, we know there's a lot of red tape with, once you receive records, how to handle those, how you dispose of them, how long do you need to hold them for, and all that. And so it's very important to develop and follow your own guidance. As I mentioned, setting up a tracking database as well. Some best practices as well. Creating templates. Now, you could say that each one of these actions, they are all different. The set of circumstances are very different between all the different cases and circumstances that you're going to receive. However, it may be helpful to have some templates so that you're not always recreating the wheel every single time that you're writing, for example, a show cause letter or the ARM, which is the most expansive letter, well, that and also the compliance agreement. It may be very helpful to just have a template on file. So establishing a method to account for each file, electronic and paper, creating a numbering system, a database, a file checklist, all this is very helpful. I would say that I think one of the opportunities for those that are starting their own suspension debarment shop or just starting their program, of course, ones that have full-fledged programs are certainly encouraged, but now, in my opinion, is the time to start getting your admin files electronic. It's a train that's moving, and it's going to be that way. So it's better if we start now. And I think we need to really stop with this with paper, admin files and all that. I think that at the very least, it's been mandated by the president. So if what I'm saying doesn't sway you, then maybe executive orders that might be encouraging. Maybe, hopefully. But it's a lot easier when you are. I've found in practice it's a lot easier to use electronic records than having large paper files, and you've all seen that before. There's a difference between the SD and the administrative file. I'm not going to go too much into that, but oftentimes the SD is what is kind of like the work product, what you see on the inside. The admin file is really what the respondent sees in the SDO. It's important to audit your work as you continue on, no matter what you're doing. If you're going through, if you're entering something into SAM, it's important for a second set of eyes to look at that entry, because the last thing you want is to make an issue in SAM, because that's the final end of a lot of this work product. And also, of course, in your in your work product, your administrative referral memoranda, your suspensions, it's important to have a second set of eyes, be it somebody else in your office or to legal review. Some other best practices, differences between intake and referrals. I said that I was going to correct myself, and here I'm going to. So I just want to be clear, and this might seem a little, like we're looking at semantics here, but there is a difference in the suspension debarment community with intakes and referrals. You hear the term referrals thrown around all the time. Most times when that's used, the wording should be intake, and that's something that was adopted about probably 2.5 years ago to distinguish the difference between just receiving a package and something that actually goes to the SDO for referral. So the intake is just receiving something, maybe if you're in an IG community, maybe you then augment that record with, with different levels of research. Then once you write that ARM, you write your entire package, you decide you're moving forward with let's say a proposed for debarment. You write that and you submit that to the SDO. At that moment, that's when that becomes a referral. And that's something that the ISTC has tried to create so everybody's talking the same language. And that's also very helpful for reporting purposes to Congress. As I mentioned, using legal interns to expand your program, it's been very helpful. I can say that at DHS, ICE, we've seen that using 2 or 3 interns a year. There's a lot of law schools in the area that would be, great great fits for really connecting the suspension debarment program to a student's legal education. Siloing the process, I talked about that. Communication up and down, and also establishing a hearing process. I also talked about those. Some best practices. It may be helpful to consider if there are petitions, that those petitions go to another SDO within your agency. That way the respondent does feel like, and also it's probably likely that they're going to get I think a more unbiased review of a petition. We didn't talk so much about petitions, but of course a respondent has the ability to come back to the government. Let's say they've been debarred. They were debarred for 5 years. They may have changed the entire scope of their company. They may have instituted different proceedings, that may now be very different in the government. If they looked at it today, they would say, wow, that is a presently responsible company. So they can petition and come back. Debarment is not time barred, but cause does age. So you've got to really look at, if that intake comes to your office, and if it may be stale. It may be that the bad acts occurred 5 years prior. Depending on the acts, 5 years may not, bar action from proceeding. Depends on what it is, but you're going to have to certainly look at that. Allowing your respondent to reply by email. These are some best practices. If you do have email, the ability for the contractor to correspond by email, it's a lot simpler than requiring them to always reply, in writing, in paper. Phone or in person through a representative. Of course, phone replies can be a little tricky, and I'm sure you all would, those that have done this before, you can attest to the fact that the respondent will always, many times cite phone conversations, and those are the conversations that really bolster the things for them. And you always have to say, well, that's not really what was said. So you have to really very, very clear when you're engaging in phone that the only thing that matters here is the administrative record, and the only thing that does matter in the administrative record is what is written, not what is spoken or said. It makes it a lot simpler and a lot cleaner in the end. And some final points. Those of you that are going to be engaging, if you haven't already, in suspension debarment programs, if you haven't already, attend the FLETC suspension debarment training program. It's a very good program. It really it seeks to tie all of what I've said. A lot of this is practical, what we've talked about today, but with some of the theoretical. So looking at that program, attending that program is a great thing. That's offered sometimes several times a year, and I know that they do offer that, I believe, down in Georgia and also up here in DC. Again, we talked about when does a conviction become too old to refer. There's not a certain time period of that, but as you start to hit years, that conviction, it might be too old, and that's really for the SDO and the suspension debarment division to consider. Again, it really depends on what that conviction was for. Of course, making the decision to impute, maybe from the owner to the company, or from the company to the owner, including affiliates. These are all decisions that are going to have to be made when we're actually making these recommendations for suspension and debarment. Do you include the period of incarceration in the debarment period? Usually, yes. You definitely will include them while they're in prison. As Maria mentioned earlier, sometimes contractors being incarcerated doesn't stop them from still having companies. It doesn't stop you from applying for federal awards, federal assistance. So it's very important to look at incarceration when you're actually instituting the period. Fact-based versus conviction-based cases. Obviously, the conviction-based is a lot easier. It's a lot cleaner. The conviction's already there. You don't have to do all the true fact-finding. The court has done that. They've given to you, it's on a platter, this is the conviction, and it's very clear. Fact-based cases, they're a little bit more complex. And of course, I think that they do lend more to disagreements and differences of opinion arising with with contractors and the government. So we'll continue, even though I think someone's telling me to wrap up, maybe.
You're done.
I guess I'm done. Final points, employ dedicated staff. I think looking at your staff is very important. Obviously, it's one of the most important things when you're engaging in this process. I don't know how where everyone in the room is with regards to their suspension debarment shops, but having the right people that are either experienced or people that are willing to learn the craft of suspension debarment, so as to assist the government in protecting itself. Mostly that protection is in the way of financial protection. Promulgating guidance and instructions, and then developing an active referral process. It's also very important to make sure that if you do have a functioning suspension debarment shop, that you do have an IG or an auditor that is ready and willing to submit those referrals or those intakes up to your office. Again, intakes can come from anywhere. They can come from COs. A CO we talked about the de facto debarment. A CO can look at a contractor and think that maybe there's something wrong here. Maybe there is issues of fraud, and they can run that through the channels. The important thing is that it comes to the suspension and debarment division. So I am done talking at you all. I don't know if you all have anything that you'd like to ask. I love questions, but I don't know if you all have anything that was unclear or anything that I can explain further.
Fred, just wanted to jump on a little bit. No questions or comments, but a lot of folks I saw at the very beginning, we're looking for the slides and things like that. There's a method to our madness here. Everybody, all agencies do things differently. We said this up front. When you get the slides, don't think that these are the only way to do business, that it's the only way to describe what you do. Take notes today. Look for the common themes. We will make these slides available on the ISDC website, but don't. The purpose today is to present an overview. There's just some things that you can't get too caught up on. For instance, arms. I don't know what an arm is, but we all do memos. Okay, so don't worry about that. It's what's in that memo that's critical. Are you providing sufficient notice, and is your analysis sufficient to withstand judicial scrutiny, should that come about? Not what it's called. When does legal review occur? At our shop, we are the legal office. We're in the OGC. And within the Department of Defense, I think you see these activities, suspension debarment activities, on the legal side. So, again, don't get too caught up on when the legal review occurs or how you should structure it. Every agency is going to have its own approach depending on how it's resourced and what makes sense within your organization. Some agencies have multiple SDOs, some don't. So if you have reconsideration, you may or may not have the ability to kick it off. So again, we all do things differently, and it's very important to keep that in mind. And see people taking pictures of the screens and things like that. It's useful, it's helpful, it will give you things to think about, but don't think it is the only way to approach business.
Thank you, Rod. Yeah, the one thing I did want to say, working at ICE, I worked there for 4 years, and where we started, and of course I wasn't there from the inception of the program, but just in the 4 years that I was there, I saw lots of changes happening. And I think the most important thing, I think what Rod's talking about is, the most important thing is actually doing and moving. Again, this is like a car. You cannot turn a car if it's not moving. And we have to start, and then we'll find out the best practices. It may be better to have that legal review, twice throughout the process, depending on your staffing. However, it works for you all. The most important thing is there is guidance. There is the FAR, the NCR. Those things you do have to follow those guidelines, but how you follow them, we can be creative in this and find out best practices so as to make the process more effective in protecting the government. So thank you all.